respect that understanding between the criminal justice or the বিচার বিভাগ and the court diversion that patients are diverted to the hospitals. I'm just going to highlight some of the criminal sections that is involved in transferring a patient or a prisoner to hospital, and what kind of instructions that is like in terms of kind of by terms of law is like the defenses or disposals by the judge or the court. I'm going to talk about it a bit about that as well. And I would like everyone to participate. Please do not hesitate to interrupt or stop me if you are not following me or if I'm going too fast. Right. So what forensic psychiatry is about? So it's a subspecialty, a branch of general psychiatry, but where we do treat the patients who have a mental disorder, but they're different from the mainstream patient group in that sense that they have elements of risk involved, and probably they had some brush with the law, and that involves treating them or looking after them in a setting that is quite secure. So as we assess or kind of progress on assessing this kind of individuals or patients, what we do is that we try to understand that exactly what has happened, like what is actually the problem in terms of their mental health, and what is the behavior that kind of contributed to him actually sitting or standing in front of the court, and that what is the interest of the court, because court will always think about the interest of the public, safety of the public, as well as consideration for the fact that this person might or might not be have a mental disorder which needs urgent attention. And there are quite a few agencies who work in this process. So obviously the police can be involved, prisons can be involved, courts can be involved, Ministry of Justice, which is like the বিচার বিভাগ in Bangladesh, provision service যারা মনিটর করে যখন প্রিজন থেকে রিলিজ হয়, প্রত্যেক ক্রাইমে ধরেন একজন ভিকটিম থাকে, তো একজন ভিকটিম লিয়াজন অফিসার থাকে যারা আমাদের সাথে রেগুলার যোগাযোগ রাখেন যদি টু আন্ডারস্ট্যান্ড দ্য প্রোগ্রেস অফ দ্য পেশেন্টস কেয়ার। And আরেকটা ইম্পর্টেন্ট জিনিস হচ্ছে মাপা, আরেকজন হচ্ছে জিগসো। So MAPA is specifically multi-agency public protection assessment. So যেটা involved হয় police, a forensic psychiatrist, social worker, specialist psychiatric nurse, and a layman as well, যে সাধারণ মানে পাবলিক থেকে তাকে চুজ করা হয়। তারা ডিসকাস করে যে প্রত্যেকটা পেশেন্ট যারা হাই রিস্ক, যাদেরকে রিহ্যাবিলিটেট করা হচ্ছে, তাদের মনিটরিংটা ঠিক মতো হচ্ছে কিনা as they reintegrate into the society. Now, does anyone know this guy? Okay, I was thinking this is a guy who was known as the cannibal killer. His name is Peter Bryan. And he actually killed the shop assistant in 1994. And obviously, at that time, he was suffering from paranoid schizophrenia with with flare of violence and very unsettled and actively psychotic. And he managed to actually come through the system, like from the high secure to the general services, and got discharged. When he got discharged, he was given to accommodation where he was residing, and there he killed a friend of him. And when police went to see him, he was actually frying part of his brain in butter, and told them that it tastes nice. If my memory serves me right, he told one of the police officers that it's really nice if you want to share. And I think one of the police officers literally fainted probably at the sight of the things. So this is the extreme version. Just wanted to give you a bit of shock to the kind of patients we can deal with at some point. So the forensic service, as I said, that it has a kind of framework. It is usually not necessarily funded by the hospital I'm working for. So এটা যেটা বাংলাদেশ ধরেন স্বাস্থ্য মন্ত্রণালয় বা এখানে যেটা বলে যে ডিপার্টমেন্ট অফ হেলথ, so they get funding because it's an expensive service, a lot of monitoring. We need more staff to look after this kind of patients. And secure hospitals, so there are three categories: high, medium, or low secure, and locked rehab. So, and then we have services in prisons. So they have prison healthcare wing. In the healthcare wing, there's a physical healthcare wing, there's a mental health care wing, which is called Enrich team. So if they have someone who they think is probably relapsing in their mental illness, or they are worried about their mental health, then they will liaise with the court or with our services to request for an assessment. And that's how the interface, as I said, between the criminal justice system and the mental health service kind of comments. We also have outreach team, forensic community team, but because of lack of funding, they are probably quite a few and far between. And all of these things that we do are kind of strictly monitored by the head department of health, which is called, they have a organization called the CQC, the Care Quality Commission. So they ensure that the quality, security, the safety of the patients and the care is up to the standard. And every good forensic service has to sign up to a kind of contract with the Peer Quality Network. That is actually is a mock CQC. So the government visits, say, my hospital and say that, okay, these are the standards met, these are the standards not met. But we can have actually this quality network. They do the mock visits. So they are actually professionals from other hospitals. And if they give a very positive feedback, which is very strict, it's a 170-page actually agenda and criteria that you have to fill up, and you have to achieve at least 96% of those criteria. So if that's good, then the government doesn't bother you too much, but they will still visit you if they think it's necessary. As I said, that our mental health service at some point and in course usually crosses path with different aspects of criminal justice system. So usually the entry points are, it can be from a general adult unit, like another psychiatric unit. It can be from a police custody, or it can be via the court, which I'll elaborate a bit more, or it can be from the prison. And the care, as I said, we are based on the risk, based on the kind of concern or the about the protection. Because one thing you have to remember is that there is always that issue about whether the patient's risk and the interest of the public, interest of the media, okay, and the safety of the public. That is paramount. So based on that, we decide, okay, what kind of facilities these patients should go through. And then if they get better, then they get a step down in due course. And I think I mentioned about that there are various organizations they are linked up with so that they can have the monitoring. Usually these forensic patients, they don't go and live independently. They usually go to a place where they are looked after by specialist accommodations, which are called 24-hour supported accommodations. And the nurses are more in tune with dealing with patients who are risky or who they have background experience in working in forensic services. Now I'm just going to give an example of how if a patient is coming towards us or to us by a criminal justice process. So it can be on the street, somebody making a lot of public disorder or nuisance. So police can actually section them or detain them there. It's called street triage or section 136. And they, under that section, they bring the patient to hospital. Before they could take the patient to custody, but nowadays they don't because of some incidents and deaths. So if they doubt anything that this patient is a bit not right or a bit acting funny, they will bring them to 136. So we have our case load is quite high in that respect. So somebody committed a crime or crime is suspected, they get arrested, mental disorder, or the person is actually, they didn't establish that this person has a mental disorder, take him into the custody, and then obviously they think that, okay, this person is really not in a right state of mind. So then they can invite the FME or forensic medical examiner who will come and decide that, okay, this guy needs to go to hospital. Then you need to understand that whether you have the right of that person, that whether he's kind of supported by an appropriate adult accompanying him, or responsible adult for him, or like a family member, or there's a solicitor or a lawyer involved or not. And based on the crime or then they will be directed to different courts. So obviously for magistrate court, it will be less serious offenses. And for crown courts, it usually involves more serious crimes, like, for example, attempted murder, or there is a serious concern to public safety being raised in that case. And just to elaborate that, if I want to that police are going to interview someone and how they kind of proceed about the whole thing. So they need to kind of establish that the person they are interviewing understand the implications of the caution, that why they are brought to the police station, and understand that whether they can meaningfully engage in that interview process when police interview them. And they can actually respond to the questions in a manner that is understandable or comprehensible to others. Whether they can understand that they can say no comments, but they can refuse answers. But if they don't have that mental faculties or understanding, whether they should be asked to offer more help, so you need to probably stop the interview and probably say that, okay, this person is probably support from a solicitor or appropriate adult. Because আপনি যদি একটা এভিডেন্স এই পার্সনের কাছ থেকে রিট্রিভ করেন এন্ড কোর্টে যান, কিন্তু কোর্টে যদি সলিসিটর যে ডিফেন্ডেন্ট যে ফর এক্সাম্পল যে ক্রিমিনাল, তার যদি ডিফেন্ডার সলিসিটর সে যদি প্রুভ করতে পারে যে at the time the police interviewed the person was probably mentally impaired, then the whole evidence will be thrown out of court. So you have to establish that. So the next two slides, I'm just going to outline that how we get involved in that process. Okay, so somebody is in the community, a mental health patient, or mentally or somebody who is relapsing. So then police got involved. So if you think police thinks that this person needs to be taken to a mental health hospital for assessment, so they will bring straight to the place of safety, that is hospital, and there's a specific unit that is called the 136 suite. So they will bring them there. It's a back door. Some of the patients, if you come to Igar, you will see that sometimes I think, oh, is this a VIP coming or something? Because probably the patient is a bit risky, so they are escorted by like motor police, like a police in Honda. Then there are like two motor cars of police in front of the actual ambulance, the secure ambulance, and there are two cars behind it. So a lot of camaraderie, and you think that, oh, probably somebody very important is coming. It is actually patient with a probably high risk. And then when nowadays a police station is not considered as a place of safety, because as I said, there have been quite a few incidents where they went there and the patients actually committed suicide or something like that. So they thought that, okay, if I am doubting that this person is not well, just bring him straight to the mental health hospital for 136 unit. And once they are there, then the senior nurse officer, they are quite experienced. They will call the junior doctor to see the patient. And if they think, okay, this person needs admission, but refusing admission, then they will call whoever is the on-call doctor, senior doctor. So these are the Section 12 approved doctors. So it can be me, it can be my consultant or anyone else that will go and jointly assess the patient and decide, okay, this person needs to come to hospital for the sake of his own safety and the protection of others. On the other spectrum, if we think that, okay, these guys are not actually, there's nothing to do with mental health, so they can be charged, they can be released totally without condition, or they can be bailed to come to magistrate court. Now, if they're charged and then obviously they usually go to custody because the court hearing takes few days or weeks sometimes. And in between, if the solicitors are clever, they can ask for bail and the court can decide if the patient is not too risky, they can be released. If not, then here I get involved. The court diversion. So they come to the court and court will say, okay, we need a proper assessment of this person, whether this person can be charged and convicted of the crime or this person actually needs kind of health attention, like that person needs to be admitted in hospital. So here I usually get involved. And the thing is that I usually deal with magistrate court, so which are like acute bodily harm, burglary, theft, serious assault. But usually the murder ones and or the senior ones, like more like high profile case, is my senior colleague, Dr. Oboro, who usually attends that court. That is the Crown Court. That's my next slide. Sorry, this is a bit hazy because I took it from I took it as a kind of snapshot. So as you can see that I'm just going to follow this line. So this is the law. So police arrest someone, interview, and decide that, okay, this person needs to be charged. So they will talk to the CPS. CPS is equivalent to আমাদের বিচার বিভাগ. So যেটা সরকারি পক্ষের উকিল বা আইনজীবী, এবং they will decide, they will advise police that, okay, you don't have enough evidence, so you need to probably have enough evidence, or whether it's in the interest of the public. So to decide that, okay, if this case goes to court, that they have enough evidence or interest to convict that person. Okay, so that is that. So this is purely criminal justice system proceeding. So then court will decide, okay, the crime is not that serious, so it can go to a magistrate court. And there are different sentences options. Now, magistrate court can say that, okay, this person is too risky, or we are not actually equipped or experienced enough. So they refer to the Crown Court. So in Bangladeshi context, that's the equivalent to High Court. High Court judge হয়তো বললো যে না এই পেশেন্টের hospital like he has to be committed to prison or something. Then the criminal or the prisoner or the defendant, they can go to the Court of Appeal. So that's above the Crown Court. So এবং সেখান থেকে they can go to House of Lords. So member of so এখানে দুইটা মানে পার্লামেন্টে একটা হচ্ছে যে lower assembly or the MPs যেটা আমরা বাংলাদেশে বলি, আর একটা হচ্ছে যে রাজ্যসভা যেখানে usually lords, they usually are involved in kind of making those letters of the law. They write those kind of laws, so they can finally give the verdict usually. Now, whilst this is happening, like this person is going through the criminal justice system or different tiers of court, it can divert in both ways. Okay, so this person at some point we decide that there's no evidence. Okay, send him, give him bail. Or he has committed a crime. There is no psychiatric evidence. Send him to prison. Or police brought him to our side, and we can give them section or detention. That is usually civil sections. Or in the magistrate court, say in the court diversion, I saw someone, I said that, look, this person is not actually fit to plead, or he's not compass mentors enough, or he understands the risk of what he has done, actually, right or wrong, and he should be properly assessed. So I will do a court report and request the court that, can you please consider transferring this patient? And then the court will, based on the my feedback, they will have to decide, okay, is this enough evidence provided by myself or the mental health service to divert this patient to an hospital? So that can be under civil section, and that can be under forensic sections. So because of the time constraint, I'm going to highlight on the forensic section, because how from prison it comes. The civil sections are straightforward, that if it's a new patient, you usually give them section 2, so 28 days. Then we have to decide whether you want to extend. If it's an old patient, somebody who we know from previous kind of acquaintances, we can then say that, okay, this person doesn't need a new assessment, so they can be switched to section 3, which is longer version, usually 6 months. As I said, in the process of this, when if the person is sentenced to prison and their mental health starts to unravel, and the disorder is on the forefront, and then the prison, in liaison with the court, can decide that this person is to be transferred to a hospital. That's why all the forensic sections comes through. So then the court will decide, okay, this person needs to go to hospital, or this person can be supervised in the community, or whether this person can be absolutely discharged or acquitted of his crime or the conviction. So as I mentioned earlier in that slide where on the table about the forensic sections. So the most common section we use is that we receive patients through is the section 37. Okay, because all other sections, you can see that validity is very short, like 4 weeks. Then it needs, then some of the sections don't allow you, like section 35, you only assess the patient, but you are not allowed to treat the patient if the patient doesn't voluntarily agree, which is very confusing and situation, and it's stressful, because if the patient is risky and you are not treating, then you are putting other patients at risk. In the section 36, you can actually send the patient for treatment, but again for 28 days that needs assessment. So it's a lot of hassle, a lot of paperwork. So ideally, if we think that this person is a mental health problem, he needs to be in hospital, then usually the best option is the section 37. That is the hospital order. But to decide on the section 37, there are other ways. So it can come from the prison, and it can come from the person who are waiting to go to prison. So that would be my next slide. So I'll come to that. And just to kind of give you the flavor, section 3741 can be, it's like a life sentence. It can be. We discharge someone who committed a rape when he was mentally unwell. He was 19 years old. If you see him, you love him. He is very polite, very respectful. He was discharged from our side. He was with us only 8 years, but he came through all the forensic units, like high, medium, and low secure. He was discharged after 24 years at the age of 44. So you can imagine the strictness and the monitoring, the vigorousness and the seriousness of this kind of the court takes. Another section is for section 47 or 48. I will not go to section that because it can get too confusing with too many sections. So I told you earlier about the section 37, which is the common section, and usually it's called the hospital order. Now, as the আপনার বিচার চলতেছে, এখন Ministry of Justice decide করলো the patient is convicted, sent to prison, but in the prison suddenly he relapsed. So they will need probably a hospital attention, and so court will decide, okay, so তার 3 বছরের জেল হয়েছিল, কিন্তু court will decide that okay now this person is to be treated in hospital, but শর্ত জুড়ে নর্মালি শর্ত ছাড়া ইউজুয়ালি কাউকে দেওয়া হয় না। শর্তটা হচ্ছে যে court will decide or Ministry of Justice, বিচার বিভাগ will decide whether they can be discharged from hospital, not the consultant in charge of that patient, or that he should come back to hospitals, to prison. So the thing is, 3 বছরের জেল হয়েছে, সে হসপিটাল গেল, 2 বছরের ভিতর সে ভালো হয়ে গেল। So the court can decide, or the বিচার বিভাগ can decide that okay, the last 12 months he should actually serve his sentence, go back to prison, and then he can be released. But 9 out of 10 times, what happened is that court says that okay, the period of the time that is the sentence he should spend in hospital, and then court along with the hospital will make provisions or conditions of his discharge. So that's about somebody who is in prison and he had a relapse on his mental health issues. But if somebody is actually waiting to be sentenced, like আপনারা জানেন কোর্টে এগুলো করতে অনেক সময় লাগে, যে এভিডেন্স জোগাড় করা, ভিকটিমের এভিডেন্স নেওয়া, আপনার পুলিশ রিপোর্ট, judge is not happy with the evidence, then ask for more reports. তখন so patient is not sentenced, so he's too risky to be discharged or released on bail, so they go to hospital. Whilst they go to prison, and whilst they are waiting for their trial, তাদের যখন বিচার শুরু হওয়ার আগে দেখা গেল যে তাদের আবার মেন্টাল হেলথ ইস্যুস দেখা যাচ্ছে, যে they are quite unwell. তখন hospital, the judge can say okay, patient যদিও কোনো তাকে কনভিক্ট করা হয়নি তার ক্রাইমের জন্য, but because of his mental health issues which needs urgent attention, he can be transferred to a hospital. So they are transferred because তাকে কোনো যেহেতু সে সেন্টেন্স হয় নাই, তাকে কনভিক্ট করা হয় নাই, he is an unsentenced prisoner. So এখানে যেটা হয় যে এটা সেকশন 48, এবং নর্মালি যেটা হয় সেকশন 48 এর আন্ডারে যখন সে হসপিটালে গেল তখন জাজ আবার রিভিউ করবে, so maybe he is convicted of the crime or not, but judge will say that because he has a mental disorder, so he should be in hospital, and this 48 becomes converted to a hospital order. So that's again I talked to you about section 37 with or without restriction based on the risk and the concerns, because they ask evidence whether this person should be restricted. That is, that Ministry of Justice will monitor their progress as they move forward. The other term we use is that notion of 37. So they came in as an unsentenced prisoner as a 48, but they become a hospital order patients or a notion of 37 or 3741. So far, any questions? It's a bit different things, kind of a different palette in it, because these are a bit unusual in the context of our country's criminal justice system and the mental health. So it might take a bit of time to digest. This is actually like assessment of a hospital order. So I just took it from one of the cases, Richard versus Sarlis. It was a 2012 case, 2012. This Mr. Sarlis, he was a 19-year-old young man, just few burglaries, small petty crimes and stuff like that. And he actually burgled, he actually attempted mugging of a elderly person. He was, then he had this stolen necklace, gold necklace, and his something else in possession. But when police arrested him, he had no recollection of the incidents. So the court has to decide. Okay, and then once he was in custody, it was quite evident that this young man, he was only 19, was quite unwell. So court has to decide that this young man has been convicted of an offense which involves a degree of violence, because obviously the victim, the 75 বছর বয়সের একজন lady, he was mugged. So she's very traumatized. তার সাথে তার নাতি নাতনি ছিলেন. They are also very traumatized by the whole experience. So the crime is committed and there is a witness to the crime. But so there is a caution. So he has been interviewed and cautioned about the battery because of the amount of force is involved. But the court also recognized that there is no indication that in his past behavior and history that he poses a risk to the public of serious harm in the future. So you have to be very careful what the last line says. So court is deciding in the interest of the public that, okay, this guy, whether he's risky to the public or he can be. So they make an assumption of the risk in the future. And based on that, they will decide, okay, this person coming to hospital or not. If he's coming to hospital, whether the risk is too high to be restricted, or risk is not that high that he can be only on hospital order. If it's only hospital order, then the consultant, who is the responsible doctor for this patient, they can actually discharge him without the court's permission. So in that last kind of a paragraph, I highlighted that the court will conclude that they have to find that balancing exercise that given the crime committed, so that needs to be addressed. And then the expert witness or professional witness will give evidence, which I'll come to very shortly. And the court has to realize the balance of judgment that to make an order of Section 37 because this person has been suffering from a mental disorder without the necessity for making an order pursuant to Section 41. So court will normally court is very quick to jump to 41 because they don't want any blood on their hand or any incidents on their hand. So, but you see that this is his first crime and court made it very clear that beyond that, there are no indication in his past history to represent the risk to the public of serious harm in the future. So court is actually making possession of his evidence of past behavior. So this guy was sent to hospital under hospital order and then released probably after 9 months. Now this is Maurice Low Secure Forensic Rehabilitation Unit. That is the unit where I work. Dr. Nurun mentioned about my workplace. So this is actual unit where I work in my capacity as a staff grade associate specialist. So it is a 15-bedded male hospital, a male unit. Sorry. We serve almost 1.5 million people in our board, one of the largest trusts in UK. But unfortunately, we are the only forensic unit and only male unit in that respect. So, but that's why we liaise with other trusts, other hospitals, if we need to transfer someone, for example, a female patient, or for example, somebody who is too risky to be in a low secure. So again, we are funded by NHS England. So we have our units are usually a bit better or probably a bit richer than general units. It only came into kind of action in 2011. So fairly new setup. We have all the resources that is expected. As I highlighted, that Care Quality Commission makes provision that you have to have that standards and the provision of care provided to the patient and to the service. And we have excellent ratings from the government as well as Quality Network. And there are specific criteria that based on that we admit these patients. So they have to have a psychotic disorder. So if that person has got a personality disorder or say depressive disorder, they will not be considered suitable or despite the risk. Usually they have to have a psychotic illness to consider assessment and treatment in a low secure service in our unit. And I'm always bragging about this, but we were voted the best low secure service in UK 2019-2020 by the Quality Network out of 116 units in UK. So there are a lot of units, especially in Oxford. There are a couple of private setups, very rich and very resourceful. Even they were surprised with the things that we offer. So we are very proud of that achievement. So how we admit or how we receive our patients from the sources, different sources. So from the slides where I showed the table, you can see that from court it can come. So it can be the court order. If the patient is in a prison, usually from the prison transfer, and usually the judge authorizes a transfer warrant that this person needs to be treated in a hospital at Goodmay's Morris Ward. So he will be specifically mentioning that which unit will be looking after this patient. He can come via PQ, যারা পিকিউর সাথে ফ্যামিলিয়ার না তাদেরকে ফ্যামিলিয়ার তাকে বলি যে বাংলাদেশে মানে আইসিইউ বলেন, এখানে এটাও আইসিইউ কিন্তু এটা হচ্ছে সাইকিয়াট্রিক ইন্টেনসিভ কেয়ার. So এখানে high risk patients, they are very highly medicated, much more stricter security in terms of looking after them. আমরা আরো পেশেন্ট অ্যাকসেপ্ট করি from medium secure units as well, or অন্য ধরেন পেশেন্ট আমাদের এলাকার কিন্তু যেহেতু আমাদের বেড ছিল না আমরা ট্রান্সফার করে দিয়েছিলাম অন্য জায়গায়. So we have to repatriate them, rehabilitate them in their own kind of borough as well. Or somebody is in intensive care, ভালো হচ্ছে না বা risk are too high to release them or send them to a general side, then we will look at the risk and we'll decide, okay, this guy needs to come to our service. আরেকটা কমন যেটা আমরা পাই যেটা হচ্ছে আপনাদের বলেছিলাম কিছুক্ষণ আগে যে hospital order with restrictions. So that patient is discharged. Usually they are not discharged completely out of the section, but they can live their life in the community. But whilst out there, they probably started refusing their treatment or they committed another crime. So Ministry of Justice will say, okay, you need to go back to hospital. Okay. So usually those patients, they come straight to us because of the risk and the procedures involved. Low secure unit niche arekta unit, it's not an unit, it's a locked rehab facility, but pura UK te mone hoy very handful of them because of the expensive nature of their service. So it also just step down from the low secure. So it's not like a hospital, it's like an accommodation, but it's locked. Like there's nurses who look after these patients and they have to return back to the unit or their accommodation or their home in a specific time. So there are rules and criteria. And now আমি আপনাদেরকে বললাম যে step down from MSU, and medium secure is quite serious, like previous bodily harm or GBH, attempted murder, even murder, this kind of patients. So to give you an example, I saw someone just before the COVID last year, Mr. X. I will not give you the kind of correct name, sorry, due to the confidentiality, obviously. So and I quite liked young man. He was only 20. That he was very keen to work and he wanted to kind of move on with his life. He was actually a Hackney gang member as well, so a bit risky background, and he stabbed someone 16 times in the chest. But by the time I saw, he didn't have much of a psychological input. He didn't have any work around his index, the offense he committed. So I advised that, look, Mr. X, I would like you to do these things, but I'm going to come in 6 months' time to see you. If you make progress in that respect, then we'll consider taking you to a lower secure unit so as a step down process. So he did really well in that 6-7 months, and then finally we admitted him in November to our unit. So that can be one way of bringing patients from other services. Sorry, this is a very busy slide, but I just wanted to kind of give a kind of flavor of what we do in one slide. So in terms of looking after this patient, our patient pool. So the full MDT assessments means that, okay, so the patient, as soon as he admitted, you have to complete the admission summary, which is quite comprehensive. ECG, blood test, and all those things within 24 hours. You need to provide the rights of the patient, like explain to him that what his rights are, and kind of give him an outline of the care plan, that how long he is expected to stay, what is expected of him, the rules and of the ward, and all those things. So once the treatment starts from the very beginning, and once the patient kind of settles, then the other in other members of the multidisciplinary team, and it is multidisciplinary. So it involves psychologists, it involves different group sessions, which is supervised by junior psychologists, and then also occupational therapists who actually organizes activities or skills so that to give them opportunity to rehabilitate when they're ready for discharge. Then we have a very close link with we try to establish links with the family, and we have a carers evening. So we invite all the family the members, or what we call usually the nearest relative that person chooses. So for Mr. X, his mother, so we'll invite her for an annual one day to show them around, and to have a flavor of how their son is looked after in our things. We have a prayer room, our chaplaincy service, so we can provide priests, we can provide imams, and any other faith if they request, then we are obligated to provide that service as well to them. Then we have a social worker, full-time social worker, and she usually works as a link between the inpatient, so the patient is currently in hospital, and also starts the process of linking up with the community team, because eventually these patients will be discharged. So to establish that network with the outside world. Then I need to, and then you have to decide all the community recovery approach. So what are the things that we can do to make sure that these patients are busy doing things they like, they are occupied with the activities. So we offer them college courses, we offer them this coping through football, so they go for football matches, which are kind of sponsored by usually the lower division football league. We offer them to go to the Peace Farm, which is like a garden where they can actually work of their own choices, or usually paid groups. And as I said, local college, they can get some skills like maths, and they help to develop them CVs. There are other courses, like somebody wants to do a building site, so they can plastering, painting, decorating. So those are the skills they can actually get experience of, and we link them up with those services. Now, once they are with us, it is very important that they understand that why they are in hospital. Okay, in the first place. So that is that index offense, that you've committed this, so you have a mental illness, but there's a element of the crime involved as well. So you did something. So it can be an arson, so fire setting, or it can be a sexual violence. So based on that, the psychology work will be evolved. So if it's a arson, then arson is fire is considered a very serious offense. So there's no, but usually the court doesn't hesitate to put them in a restriction, even if it's a first admission in their life, a first contact with the mental health service, because you can imagine that a fire can cause a lot of havoc, a lot of damage, a lot of loss of lives. So there's a very, very low threshold to convict them and obviously divert them to the hospital if they are unwell. Or if they have a sexually deviant behavior, like they have assaulted someone sexually, or they are very high risk of actually committing sexual offenses or related crimes. So that then they have to, their treatment modalities are based on RSVP, so risk of sexual violence prevention. Okay. And so once they go through the specific kind of themes of psychological work, then they have to focus on what they need to do to have a relapse in their mental illness. That is called PRISM. Usually people confuse it with prison, but they are not being sent back to prison. It's a prevention of relapse in mental illness. That's the PRISM group. Again, it's organized by the senior psychologists. And then if most of like 8 out of 10 patients have a problem with the substance like cannabis or legal highs and all those things, or alcohol, so we make sure that that would be one of the conditions of their treatment, that they need to attend those groups to understand why the taking drugs or doing the taking excessive, drinking excessive alcohol is not good for them, and they should be not doing it, and they will be supported doing it. So on the red, so that's kind of in a nutshell we do in a forensic setting, and it doesn't differ much from other senior setting except the higher security services, higher security unit, but medium secure or low secure, these are the kind of flavor you get, the things you do. Oh, I forgot to mention, we also have what we call inside the unit, we have a seclusion room. So if the patient suddenly gets quite violent, or we think that he is risky to other patients in the ward, we put them in. We take their liberty. Basically, we put them in this room, which is like a completely locked room. They are monitored 24 hours, and they are reviewed every 4 hours. Okay, depending on how serious, because their presentation is. Normally what happens is that that person suddenly becomes violent or seriously assaults another patient or a member of the staff, or did something quite dangerous that for them to stay in their room and be treated is not possible. So they are taken to this room, which is the seclusion room. And just to give you a flavor how that sometimes patients, because we get all sorts of patients and they are so unwell or so high in terms of their mental illness, so they damage the wall or they try to self-harm or do things to kind of attract the attention of us or the people who are looking after them. So we have made the room kind of bouncy. So the whole wall of that seclusion room, they are actually, there's a specific term for it, I forgot. So if you actually bounce on that or hit your head on that, you will be bounced back. So you'll not get injured basically. And it's difficult to kind of hit yourself. And apparently just 4 walls, it is like a small room, the room like mine. Just to put that wall, it costs 100,000 pounds just to put the wall, the 4 walls. So that's how expensive it is. And we also have another service which is called pet therapy. So we have pets, like we have rabbit, chickens. They're laying eggs like left, right, center, and then we have guinea pigs. So some patients like to nurse them and look after them because we have a small garden. And we also have dog therapy. So every 3-4 months, a professional, usually charity services, they bring the dog, and UK people in UK, they are great dog lovers or pet lovers. So a lot of patients like that. So they like to spend some time with the dogs and have a feel of kind of normality, that things they can enjoy whilst they are in the community. So give them that opportunity. We also have sudden unannounced visits from the dog squad. So it's a police dog squad. The sniffer dog, the dogs, they will come and go. We'll choose randomly. If we have a suspicion or index of suspicion that this patient needs checking, then these specialist trained dogs will come with the police, and we'll kind of check those rooms to see if they have hiding any or in possession of any illicit drugs or not. And all the patients, irrespective of they have leave or what kind of monitoring they are subject to drug and urinary drug screening, as well as breathalyzing tests. Okay, so they have to be subject. If they refuse, then we consider it as a positive test. Now, I told in the red highlight in the previous slide, I mentioned about the risk factors. No forensic patients cannot be discharged or kind of passed through unless they have this template assess. So this is this is a risk assessment tool. So all patients will have to have this risk assessment, who come under the umbrella of forensic services. So it's called HCR20. So you can see the acronyms that H is the historical risk factors, C are the clinical or current factors that is driving the illness or the issues, and R factors are the risk management or risk of relapse. Okay, the future management of risk. And you can see that there we go through that. What was the issues in the past? How they grow up? What was the problem in the family? Okay, if they had mental health problems when they were a child, if he was an abused child, if he was a victim of abuse, sexual abuse, if he was under foster care or social care. And this scale is updated every 3 years or 4 years. So there's no longer the psychopathy because people objected to that as quite derogatory. So it is kind of pulled into personality disorder. So that trait is under the umbrella of PD patients. And then you can see that despite all the support they had in the past, they didn't engage with the mental health services. So that means that they had supervision failure despite the intentions of the mental health services. Then you look at the current problems, that whether he is improving or is actually his condition is deteriorating, whether he needs more support or more input, or whether he needs to be referred to a more secure service than ours. And then when patients are almost ready for discharge, then we look at that whatever plans we have made, it's going to work or not, that it is safe, and that what are the factors, because we have patients who are ready to be discharged, quite nice, but all the drug dealers and those antisocial elements, the thieves, thugs, and dealers, they're actually waiting outside for this guy to come because they're vulnerable. So to use them as drug runners or things like that. So if you discharge them in that community, chances are he's going to relapse again, isn't it? So because he will be intimidated, bullied by those people. So you have to find a place of safety where they can function independently, safely in the community. So whether they're exposed to these things. And then how much support do they have family support or not, and whether they're going to take their medication or not. So all those things. If I get the opportunity, one day I will probably show actual HCR20 assessment report, the proper clinical report, which is like 20-30 page. But I can go through the individual because that in itself can be a full lecture. Mm-hmm. So I'll take the names off and things like that, and I can show it to the people if they are interested at some point. And finally, we go through the score. So 0 means that you are getting better, and 2 is the highest score. So you scored them. Okay, the risk of violence or the violence he had committed, that was very high. You need to assess right now that, okay, the risk is actually reducing or is actually going up or is still high. And then when you are going to discharge, you need to decide, okay, risk is coming down or it's 0. Like he's getting better, he's compliant and things. One thing doesn't get 0 is that, whatever the historical factors are or the committed crimes. So that risk is still there because that can happen in any context if he relapses. So that usually gets reduced, but never 0. So we scored them. This is a qualitative tool. So we look at the kind of different aspects of the care. As you can see, on the basis of their kind of previous risk, current risk. So it's not a definitive tool. So just to be mindful of that. Right, I'm going to stop now. I still have halfway to go, but any questions so far? Nurun, can you hear me?
Yeah, I can hear you. Question? Yeah, thank you so much.
If not, then I'll proceed, okay?
Okay, yeah, go ahead, yeah. Mm-hmm.
So this is the slide. I think just take a mental note of it. You can see, obviously, somebody is getting punched by a quite irritable person, probably drunk. Usually happens on a Friday evening or Saturday evening. And you can see the lady in purple, probably she's a nurse. She's trying to intervene. So just take a mental note of that. So based on that, what happened? So say that guy on the left, he punched that ambulance crew or the paramedic. So the act of violence, or ABH usually called, acute bodily harm, is committed because he assaulted the health professional. So the person who did that, obviously, he's the perpetrator or is the defendant. The person who got attacked, he's the victim, obviously. And the lady in purple, she is actually witness to what exactly happened. So she was witness to the crime. So just in case this goes to court, they will be asked to give evidence. Okay, what you saw at the time. Okay, so that nurse needs to provide evidence. The victim needs to provide a statement that this is what happened. My jaw got fractured, or I lost teeth, and etc. etc. Now, if this person who was the defendant, or the person he was probably is drunk, he will be obviously looked after by a doctor, attending doctor. So usually in Bangladesh, আমরা জানি ঢাকা মেডিকেলে ক্যাজুয়ালিটি ইউনিট আছে বা বিএসএমইউ তে এমার্জেন্সি সার্ভিস আছে। সো সাপোজ ওখানে একজন মেডিকেল অফিসার ওনাকে দেখলেন। In the context of UK, it is the accident and emergency department. So attending emergency physician will see that person. And obviously তাকে ক্লিনিক্যালি এক্সামিন করে ডিসাইড করবে, ওকে সে একটা ফাইটের ভিতর ছিল, কাকে হিট করেছে, what he did, and document everything. So he can be actually invited to the court to provide evidence that, okay, you know what happened. You are not a witness, but you know what has happened, and can you give your professional opinion on what you did? So he's a professional witness to the accounts of the incidents. Okay. But expert witness is totally different. Expert witness is someone who has the knowledge and skills in the respect of, I'm talking about in the context of obviously psychiatry. So they will help the court to understand, the technical terms or specialist terms in terms of the illness. Okay, so to help the court proceedings. And so the court usually they can be appointed by the defendant, so the person who is actually committed the crime, or by the CPS you saw in my earlier slides, Crown prosecution, that is the government side, like a সরকারি পক্ষের আইনজীবী. And law commission defines the expertise that who is qualified to give expert evidence by virtue of his study, training, and experience. These are usually very high-skilled forensic psychiatrists with a lot of experience in attending these courts, and a lot of them are actually have a law degree as well in the proceedings of the courts and understanding the criminal justice system to support them to understand why the illness is prevalent, more important than the actual crime that was committed. So they have those. So they have specific criteria that they have that experience. Their opinion comes from those experiences, and it is based on the facts, and they have the skills to demonstrate that. Now, next slide. No, sorry. আপনি যদি expert witness দেন, usually আপনি court appointed হন, you get paid. So you get quite paid quite decently, and the court can decide. So defendant can actually ask for an expert opinion, or the Crown prosecution can ask for an expert opinion, and obviously you're paid. So you have to declare that, okay, you got paid by this kind of services, and that but your obligation is to the court. So just because আপনি সরকারি পক্ষের আইনজীবীর হয়ে আপনি একটা কোর্টে এভিডেন্স দিলেন বা একটা কোর্ট রিপোর্ট লিখলেন বা সাইকিয়াট্রিক সামারি দিলেন, doesn't mean that আপনি knowing fully well that আপনি হয়তো আপনার এভিডেন্সটা যাচ্ছে সরকারি পক্ষে. That is a biased with. So it has to be based on the facts, and it has to help understand the court, the judge, and the jury to better understand the proceedings of what has actually happened. So you cannot take sides. And that's very, very important, that you have to declare that what you said is based on the facts, and you are not gonna, although you are being paid for by, say, the defendant or the criminal or the prisoner, you are not going to write report just because you get paid by them that in favor of them. Okay. Because if you do that, then you are perverting the course of justice and you will be actually charged for that. Now, this is the kind of famous case that kind of set the precedence of people with mental illness, whether they are, or people with questionable mental faculties, whether they can actually stand to, they're fit to stand trial, or they understand the proceedings of the court. And that is the famous case in 1836, R is the CPS or Crown Prosecution Service versus Pritchard. Mr. Pritchard actually committed a crime which is bestiality. And in those days, that was a capital crime. And he was deaf and mute. So, it's very difficult for him to understand a proceeding. But so the judge has to set the precedent that, look, this guy, probably by the visitation of God, that's the word he used, he's deaf and mute. So you need to establish whether he understands the charges, whether he understands why you brought him to the court, whether he can actually provide evidence for what he did, or defense for what he did, whether he can give his instructions to his solicitors or legal representative that will be supporting his case, or he can follow what's going on in that court. Okay, that he can understand, okay, what jury is saying, what he can object or pass the information that if he thinks if his is unfair to him, that he can actually communicate that problem. And that he can challenge any juries if he thinks that something said to them or they trying to deliberate is false or not in his best interest. So he needs to fit those criteria to be able to stand the trial. If he's not, then you are not. Unfortunately, I think this is the judge. He was the Baron of Exchequer. He was quite senior judge, and he actually specialized in commercial law because Britain was busy at the time. Their what you call their empire, the whole world. So he was specializing on those business laws when they broke it, and he set up a lot of precedences about how things should be. Yeah, but somehow he was brought in to chair this case, and that's how this precedence about fitness to trial was initiated. Unfortunately, I don't have any pictures for Mr. Pritchard. So this is just to give an example of because the jargons of the law, the kind of the words they use in that court, they are quite heavy. Like even if you are fluent in English, even if you, I think if you are locally, you went to school here in UK or even in America, it is very, sometimes it's difficult to when I follow unless you are not quite used to it. But his lordship, that Judge Alderson said that because this guy is moved by visitation of God, he and the juries are being kind of oath niyeche, that they have to prove that defendant was able to plead with knowing all the evidence, and they can actually, defendant can understand that what he's charged with. So he should have the sufficient intellect to understand the court of proceedings to make proper defense. And so that the things I highlighted in the previous slide. But actual wordings are so difficult, like to comprehend if you are not used to those kind of if you are not following those case laws or case references. Now, this I'm quickly go through this, but this single slide is actually probably 5 lectures. But I'm just going to say that when a crime is committed, so there are 2 parts of it. Okay, so these are actus reus. So that's what has actually happened. So I told you about this guy I brought from medium secure to our services, that he actually stabbed someone. So that's the fact. Okay, he actually stabbed someone 16 times. There's no issue about that a crime is committed. Now, that is actus reus, yeah? Mens rea is the one where things get really complicated. So mens rea is the mental element that this person who committed the crime he has a criminal mind, that he had specific, it's not motive. Motive means the reasons, but secondary, tertiary or gains. It's not motive, it's about his mental faculties. He knew what he was doing, he knew the consequences, he knew the damage he can proceed, and he knew that what by doing so he's actually guilty. So all those elements of the mental health aspect of the crime he needs to understand, and that's mens rea. But where I get involved, or where we get involved, is about the psychiatric evidence is not admissible. So I cannot actually lecture them on, okay, this person was, I think a mental element is questionable. No, you can't actually say that, because the jury will decide whether the mental element was actually present or not. Okay, that he had the criminal mind and he had the intent to do what he did. But the psychiatric evidence here is that whether or not that accused who did this had a prior condition, and by prior condition I mean a mental health issue that affected his ability to form a particular intent to commit the crime. Okay, so that it clouded his judgment. He did what he did, but he didn't understand the consequences. He didn't understand that what he was doing was making guilty of the crime, that there will be consequences of the crime. Okay, so that's where the psychiatric evidence is. That's where the expert will give that, okay, there is a precedence, that antecedent, that okay, this guy has had illness. There's a precedence. The antecedent is that this is what has happened, and that the chances of this is happening is high or low based on whether he has got a mental illness or not. So that's an observation from the outside as a psychiatric expert evidence. But you cannot actually comment on that. When the person is committed, I think he was completely insane or he was mad. That's why he did what he did. You cannot actually comment on that because you are not there. But you can make assumptions based on the evidence and based on the interviews that we will collect during the course of the hearing. So once the crime is committed, there are usually some kind of defense. Obviously, the defendant or the guilty, the person who committed the crime, they will say that, okay, I don't use the word mad, but yeah, I'm insane. Basically, I don't take any responsibility for what I did, because some of the patients will. Because they have history of violence or things like that, they want to go under the wings of their mental health issues to get away from the crimes, and unfortunately, a lot of times they do get away with that. So these are the defenses they can come up with. Now, again, the insanity defense was based on the case that involved this guy. If you are familiar with forensics unit, then you will. We have to know this. With this is Mr. Daniel Magnacton. He specialized in doing woodcraft, like আমাদের furniture maker, আমাদের দেশে বলেন না যে কাঠের কাজ করে, কাঠমিস্ত্রি, Scottish guy, and he went to normal school and things like that. But when he was 30, I think, he went to London, and with the plan that he needs to kill the Prime Minister at the time, Sir Robert Peel, and in the process of that, he actually mistook the Prime Minister's private secretary, Edward Drummond, as the PM and shot him dead. And he told the police that the only reason he came to London, he was very confident, very clear that he wanted to murder the Prime Minister to get away from his problems. What was the problem? Problem was like Amader Awami League and BNP. There are two parties you probably are familiar with, Conservatives and Labour Party. So Conservative, there are a nickname, they are known as Tories. So the Tories সে তখন পুলিশকে এভিডেন্স দিচ্ছে যে এই মানে অ্যাকচুয়াল এভিডেন্স আরো অনেক একটু মজার, বলছে দে আর সব বদমাইশ, দে আর ইন দ্য সিটি, দে ফলো মি এভরিওয়্যার, whatever I do, they criticize. whatever wherever I live, they destroy my property, and they do everything in their power to kind of intimidate me, bully me. So obviously, a defense counsel was that this guy doesn't make sense. Okay, that because of somebody bothering you or not in Scotland, that you came all the way to London to kill the prime minister. So they they provided expert witness, and the witness to the kind of crime as well. And there's obviously, it was evident that Mr. McNaughton had crime resolution as well as kind of disorder and some active symptoms that he was suffering from. So he was obviously categorized as having a